Can everyone hear me okay, including at the back? Okay, thank you very much, everyone, for being here. I'm just going to bring up my notes. A very big welcome to everyone here. It's really great to have you, and hello as well to anyone online. Great to have you with us as well. My name's Daniela Locke, and I'm a postdoctoral fellow at the Rwanda Institute of Human Rights. And we're gathered here today to hear from this brilliant panel on the topic of the UK Bill of Rights Bill and the future of the protection of human rights in the UK. Some of you may know the Bill of Rights Bill was due to be considered by Parliament earlier this year. So it sought to make a number of changes to our current human rights system. This includes repealing the Human Rights Act. It included asserting the supremacy of the UK Supreme Court over the European Court of Human Rights. And it introduced a number of new tests that judges must apply, UK judges, must apply in adjudicating ECHR rights. For now, consideration of the bill has been deferred. However, there are a number of things not currently clear with regards to the bill. So these include whether the bill has been dropped for good, and whether the government will seek to bring forward any other changes in the bill, in other pieces of legislation. We're also not clear whether the government will seek to make alternative changes to our current human rights system, such as withdrawal of the UK's membership to the ECHR, as some people in the government and people who have very recently left the government have touted as an idea. So for these reasons, we feel it's still valuable to discuss the Bill of Rights Bill and where we may be heading with regards to the future of human rights protections in the UK, including if we see a change of government. We have this brilliant panel here to have this discussion. Our discussion will take us to around 6 p.m. Before we open up for a Q&A. I'm very grateful for these brilliant panelists to join us this evening. I hope you don't mind that we're going to have just some short introductions because we've got a lot to get through this evening. So first, we have Dominic Grieve KC, who is a barrister with a really long experience in government, including as the Attorney General for England and Wales from 2010 to 2014. Mr. Grieve KC was also the chair of the Intelligence and Security Committee from 2015 to 2019. We have Professor Tom Hickman KC, who is a professor of public law at University College London and barrister at Blackstone Chambers. We have June Pang joining us as Policy and Campaigns Officer at Liberty, who led Liberty's campaign to defend the Human Rights Act and helps to convene a coalition of hundreds of civil society organisations to build capacity in campaigning on this issue. Finally, we have Professor Gavin Phillipson, who has held the chair since January 2007, is now at University of Bristol and is currently visiting fellow at the Bonavero Institute. So, many thanks all of you for being here today. I'd like to begin by hearing a little bit of background about our current human rights system, and that includes about the Human Rights Act. So, what is the Human Rights Act and how does it function to protect human rights in the UK?
Shall I go first? Once we'd signed up to the European Convention on Human Rights, which we in part were the creators of in the late 1940s, and once it became apparent that we were going to allow individuals to bring claims to the European Court of Human Rights, it became frankly necessary to incorporate the human rights, the ECHR, into our own law. Because otherwise what was happening is that people were going to Strasbourg in order to get redress, and our own laws were not necessarily compatible with some of the judgments of the Strasbourg court, which nowadays moved slowly but surely to describe as unlawful practices which at the time were regarded as completely lawful. Corporal punishment in schools, one example. Obviously, eventually, all the issues about criminalizing homosexuality is another. There are a number of such examples, and the United Kingdom from time to time fell foul of the Court of Human Rights over our treatment of detainees in Northern Ireland and the interrogation techniques we used in the high point of the Troubles in 1971-72. So that was the motivation for doing it. And it was done in a minimalist way by the Labour government, in fairness to it, in 1998. My own old party, because I'm no longer a member of it, but the Conservative Party, although we raised a number of objections and concerns, we didn't vote against it at third reading. And it went through, and obviously the key part about it was that it did not impinge on parliamentary sovereignty, because it could not lead to the overturning of primary legislation, which was the key factor, unlike our membership of the European Union. That's why we signed up to it. And since then, it's led to significant changes in our legal system, often not through the prism of court judgments. Because it's worth bearing in mind that probably what's been much more profound was that administrations and administrators had to review their own internal practices and look at compatibility with the Convention and the Human Rights Act, or face challenge. So in fact, a huge amount of those changes took place without any litigation involved at all. And then there was litigation in certain circumstances. I know, picking out cases, you can go away and read them yourselves, I was about to say, but small things sometimes. The fact that elderly couples were being separated in care homes, put in different care homes, was found to be a breach of a right to a private and family life. So it forced local authorities to change that practice when they had two elderly people who were being put in care homes, and in the past they didn't pay much attention to it. So I want to emphasize those small things, which to my mind matter much more, I think, in the long term than some of the bigger issues that have arisen. And I think that was the question you asked me, so I think I will confine myself to that. I'll be happy to talk later as to the origin of the Bill of Rights, which is a slightly separate subject.
Great, thank you. Was there anything anyone wanted to add about the Human Rights Act, how it functions, Section 2, Section 3? Yeah, that would be fantastic if you could just outline the kind of some of the key provisions.
Okay, so the Human Rights Act incorporates, as we've just heard, the European Convention of Human Rights into domestic law. Now, it wasn't only a necessity or a practical necessity in order to try and ensure that people didn't have to go off to Strasbourg to vindicate their rights. There is an obligation under the case law of the European Convention of the European Court of Human Rights to ensure that in substance the rights are incorporated and capable of vindication in domestic law. It's very clear that there's no particular way or manner of incorporation that's prescribed. That's left to member states. But the case called Smith and O'Grady made it very clear that in substance there has to be a way of vindicating rights. And that indeed arises under Article 13, which is the right to an effective remedy for the breach of rights under the Convention itself. So how did the Human Rights Act incorporate? How do we choose to do it? Well, there were three principal ways that the Human Rights Act, there are three principal ways that the Human Rights Act incorporates convention rights. The first is that it makes it unlawful for any public authority to act inconsistently with a convention right. Now that means that if any public authority, whether central government or local authority or a regulatory body or any statutory authority acts in a way which is inconsistent with the convention right, it acts unlawfully, okay, as a matter of domestic law. It doesn't mean it commits a criminal offence, but it's the same as any ground of administrative law unlawfulness, and the court will correct that. So that's the first form of incorporation. The second form of incorporation is that legislation, and not just acts of Parliament, also secondary legislation, statutory instruments and other forms of legislation, have to be read, so far as possible, in a manner consistent with the rights under the European Convention on Human Rights, and that's Section 3. That's been controversial because it's led to some straining of the language of legislative provisions in order to make sure that they are consistent with convention rights. The third manner of incorporation is the feature of the Act which was quite innovative, which is Section 4, which allows the courts to declare primary legislation incompatible with the European Convention on Human Rights or with specific rights. But that doesn't allow the courts to strike down primary legislation or find that it's invalid. And that's the way that it tries to reconcile parliamentary sovereignty with enforcing convention rights. But that does trigger a power for the government, a Henry VIII power for the government to correct or amend the legislation to bring it into line. So although the courts themselves won't do that job, it is implicit in the scheme of the Act that legislation will be corrected. And in every case in which there has been a declaration of incompatibility, and there haven't been many, but there's been more than a dozen, either Parliament has corrected the situation or the government has corrected the legislation. So that's, in general terms, the way the Human Rights Act operates.
Fantastic, thank you for that, Tom. Gavin wanted to add something?
Just one thing to add. I mean, partly because it was one of the central targets of the Bill of Rights bill was the link with the Strasbourg Court's case law. So that's Section 2, which I'm sure you all know. Courts must have regard to it, which the courts turned into a kind of flexible mirror principle where, broadly speaking, they would follow the Strasbourg case law where it was clear and consistent with exceptions that sort of built up over time. But that was quite also an important feature. And the UK courts were pretty enthusiastic about that. And I read some comparative work that said actually they're more scrupulous about following Strasbourg case law than most of the Western European constitutional courts, partly because they often are primarily following their own domestic kind of Bill of Rights or constitutional rights charter.
Great, fantastic. Thank you for those explanations. So what we have is a piece of legislation which, at least under its stated aims, was about bringing rights back home, protecting parliamentary sovereignty, while incorporating ECHR rights into domestic law. And yet, we've had kind of rumblings from successive governments about this piece of legislation kind of not operating effectively to protect Parliament's role with regards to the protection of human rights, with giving too much power for judges. And I just wanted the panel members to explain in a little bit more detail kind of where has this skepticism about the Human Rights Act come from, which has ultimately led to the introduction of the Bill of Rights Bill. June, would you like to kind of, if you can, give a little bit of background to that? And then I'd be very interested to hear from Dominic.
Yeah, absolutely. I guess it's a really good question, and I would kind of even take it, backwards to I guess, before the inception of the Human Rights Act, and it's kind of, I'm sure Dominic will be able to speak to that. But I guess from the very beginning, if we think in terms of the wider political context of what was happening at the time when the Human Rights Act came into force in 2000, and then, it was brought into being by a kind of new Labour government. It was this kind of moment for New Labour to think about enshrining and incorporating protections from the ECHR after a long period of restrictions on rights, including, for example, trade union rights, strike action. But then, very soon after the Human Rights Act came into force, we had 9/11 and the War on Terror, and suddenly the very party that kind of, championed and tried to bring forward the Human Rights Act, and of course that was in itself, there was the original person who thought of the Human Rights Act passed away, and then it was Tony Blair's project to take up, had to confront this reality where actually it wanted to restrict people's rights in ways that the Human Rights Act would actually not allow it to do, or would make it more difficult to do. And so even it had a very uneasy birth, I would say, and then of course over the years, as we've seen kind of on both sides of the political spectrum, increasing ideological attacks on, for example, migrants' rights and refugees' rights, and Article 8, right to private and family life, the Human Rights Act has come under consistent threat, whether that's kind of, in the political sphere, but also in the media. And obviously that culminated in, direct threats that we saw in 2015, 2019, and then more recently. But all this to say, I guess the political rumblings, you could say that it had shaky foundations, and then it kind of goes to show the difficulties that bedding in such a piece of legislation can pose, but actually the importance. And of course, the Labour government at the time did, invest in a public education program around the Human Rights Act with public authorities that were suddenly thrust with a lot of, new responsibilities and duties in needing to uphold human rights. But we didn't see that kind of followed through, and that was why, for example, the independent panel, the Human Rights Act review, which I'm sure we'll talk about, recommended again that we should have a public, scheme of education around human rights as something that we have ownership of. But I realize that kind of fast forwards, and maybe other panelists will want to speak about even before then. So.
Yeah, great. Thank you for that, June. Yeah, Dominic, can you tell us your perspective on kind of where the skepticism about the Human Rights Act might come from?
I certainly agree that having enacted it in a sort of high-flown moment of civil liberties pride, the Labour government came to backtrack on it, certainly as the result of 9/11. I think it's easy to forget the extent to which the Labour government backpedaled, and particularly when the first decision over the detention of suspected foreign terrorists was found to be discriminatory because it was a permanent detention. The Belmarsh cases, when that happened, it sort of broke their passion for it. And we can see other examples of it. Prisoner voting is, I think, another very interesting example. The Court of Human Rights in Strasbourg said that our blanket prohibition on prisoners voting was unlawful, contrary to the convention. But Labour absolutely sat on its hands and did nothing about it between 2006 and 2010, when it handed it over as a poison chalice to the successor Conservative government, which also tried to do nothing about it. You can make arguments both ways as to whether the Court of Human Rights was correct in that decision. I happen to think it was mistaken. But actually changing the law proved at the end of the day, in fact, it didn't even require a change of the law. It's the only incompatibility I can think which was dealt with by minor administrative change, by a rather clever move by David Lidington when he was Justice Secretary, thus ending the problem by allowing some limited voting to people released on license. So actually, all the political parties have at times found it uncomfortable. But it is right to say that the Conservative Party seems to have found it even more uncomfortable. And this, coupled with a head of steam that built up against the convention, largely on the back, and the ECHR, on the back of the development of privacy law by some sections of the press, is, in my view, the reason why this issue never went away. So if you went to a Conservative Party conference, as I occasionally did, if somebody wanted to get loud applause from the rank and file of the party denouncing the Human Rights Act and rights culture and the fact that the rights were being claimed by undeserving people, as it was seen, and who were thereby imposing their demands on the law-abiding who didn't require these rights, was the sort of toxic underpinning of the attack on the way the HRA was worked. And bear in mind, David Cameron in 2015, 800th anniversary year of Magna Carta, he made a great speech at Runnymede and around that time, saying that how much Britain could be proud of its rights record, and actually extolled the principles of the convention, and then went on to criticize the way it was being applied by judges. So it was aimed at, it was judicial, it was irritation with judicial application, both in Strasbourg and also domestically. Although, ironically, this happened at the very moment when, after the Brighton Declaration of 2012, which led to a reform process in the way the ECHR worked, and changes with our own domestic courts being more robust in challenging European Court of Human Rights decisions that they weren't comfortable with and pinging the ball back, which happened on a number of occasions. Actually, the number of things to get irritated about was tailing off very rapidly. But it's remained implanted. And remember that in the 2015 Conservative Party manifesto, there was essentially much of what was now in the Bill of Rights. The only thing that happened after that is Theresa May. It was a condition of my supporting Theresa May and David Davis, MP, supporting Theresa May, that she would not touch the Human Rights Act in her post-2016 iteration, and she didn't. But once she went, although Boris Johnson claimed he was very comfortable with the European Convention on Human Rights and the Human Rights Act, he, once Dominic Raab, who used to be my chief of staff many, many years ago when I was Shadow Justice Secretary, and who's had a bee in his bonnet about this for a very long time, but once Dominic Raab became Justice Secretary, he revived it, and Johnson allowed him to do it. And so the genesis of this bill, when I read it, I could see it all in what Raab had been writing in 2007, 2008, when he was my chief of staff, or just before he became my chief of staff. And you could also see it in the 2015 Conservative Manifesto, and actually the paper published by the Conservative Party shortly before that, which was really sort of gamma minus at GCSE. It was full of factual inaccuracies, written by Chris Grayling, who was at that time the Justice Secretary. So that's where the origin of this comes from. And if you look at it, and you look at the proposals and what was in it, you can see that it's designed, firstly, to try to uncouple the interpretation of the convention by our own courts from Strasbourg jurisprudence, to remove the duty to interpret legislation compatibly, so trying to sort of repatriate it, and then at the same time imposing certain clear rules on our own courts, particularly in respect of deportation cases, to facilitate deportation, and requiring Parliament's views to be given more weight, preventing the human rights claims arising from overseas military operations, quite a big topic we might discuss later, and then finally this privacy bit, which in truth is what the press have been worked up about. They don't like privacy law, and so by bringing that in, you were bringing the press on side in order to attack the way in which the convention works. Sorry, that was rather long.
No, thank you so much for that. That was really interesting. And I'm very happy that you introduced some of the Bill of Rights bill, because I'd now like to discuss some of the substance of that. In particular, I'd like to hear more about the freedom of speech provisions in the Bill of Rights, because one of the justifications the government gave for introducing the Bill of Rights bill was to strengthen freedom. There were much needed protections for freedom of speech that were needed to be introduced. I'd like very much to hear from Gavin on the freedom of speech provisions. And then afterwards, I was wondering whether we could hear a little bit more about the kind of Article 8 and deportation context, maybe from Tom, and then June and Dominic, if you've got anything to add on that. So Gavin, thank you.
Thanks, Daniela. Yeah, I've been thinking about, clause 4 it was, maybe again, who knows. And I think it's a nice, I think there were bits of the bill that were kind of serious but perhaps a bit sinister, and then there were bits that I think were just a bit silly, and this struck me as fundamentally not really serious policy making. Partly because I think, and I think for sort of 4 reasons, partly because I think that the aim was a weird mixture of, yes, as Dominic has said, kind of clamping down on privacy law, but also maybe sort of defamation law a bit, but also kind of a clamp down on wokery and cancel culture, which I kind of thought, do you actually know, do the ministers talking about this, presumably they must know that actually some of the key cases protecting highly controversial speech that some people would call hate speech the Miller case on transphobic tweets, or was said to be transphobic tweets by a police officer, that protected them so robustly that several colleagues of mine wrote very angry blogs about how this was actually protecting hate speech and misusing Article 10, but very strong defence there. And of course the Forstater case, using in this case EU-derived law, the Equality Act, to protect the expression of what some people call gender-critical views and some people call transphobic views. So actually European law in two different guises has very strongly protected the kind of speech that conservatives are worried is under threat. So there was no instance of this speech, of this legislation somehow being used to clamp down. It was generally cultural matters, or universities making particular decisions, or people being disinvited from speaking and so on, nothing to do with the law. So that bit struck me as just completely misaimed, as maybe just a kind of rhetorical justification to kind of whip up some kind of support for it. The other bit, of course, was that it wanted to give great weight, but there were three. One of the wonderful things about the bill is there were three different levels of things that the judges had to do. They had to give sometimes particular weight to certain things, as was in the Human Rights Act, which actually none of which actually made any difference to anything. Then they had to give great weight to freedom of speech, except in certain situations. Then they had to give the greatest possible weight, which must be more than great, which itself must be more than particular, to certain other considerations. But you only got special protection for free speech, essentially, as long as you're not exercising it against the state, which just struck me as completely, I've never seen anything like this in any kind of charter of rights kind of around the world. So the great weight free speech wouldn't apply in criminal proceedings. It wouldn't apply if you were considering whether to allow someone into the country who might be controversial. It wouldn't apply if you wanted to deport someone because of things they've been saying. It wouldn't apply if national security was an issue or where confidentiality was an issue. So cases, for example, like the famous Spycatcher case. I mean, I know the press gets cross when it loses privacy cases, but I think we'd all be fairly clear that the principal threat to free speech in terms of being able to throw you out of the country or put you in prison is and has always been the state. So the idea that you have special protection for free speech but not against the state, I just think was somewhat ridiculous. So I mentioned the kind of incoherence in terms of wokery. On privacy law, which I'm glad Dominic kind of confirmed my suspicion, this has been about sort of quite press-led. I mean, a weird feature of that was that Suella Braverman, who has been sacked, in case you haven't seen, which is, I think, a great advance for the protection of human rights in itself, not to have her as Home Secretary. She was chuntering on at the Conservative Party conference about how it would be a good idea to introduce anonymity for criminal suspects pre-charge. Well, that's the most recent decision of the Supreme Court in ZXC, produced by the very hated use of Article 8 through the Human Rights Act under what's now called misuse of private information. So it seems that's kind of good and bad at the same time. But there was also a target, reputation law seemed to be a target, but Parliament had very recently, an example of what some people call legislated rights, so relying on kind of legislatures to kind of strike very careful and worked out balances between, on difficult rights issues, like the balance between reputation and freedom of speech. In the 2013 Act, the Defamation Act, which followed a very long kind of civil society campaign, really very pre-legislative scrutiny, draft bills, all the kind of stuff you'd want to see. Parliament struck a very careful and considered balance between these two things in a way that is now being kind of worked out by the courts. Somehow they were now going to be asked to sort of, presumably by defendant counsel, would be able to say, oh no, this has all been overtaken now. You can't strike that balance. You've got to give the greatest possible weight to free speech. No one knew what that would mean. There were two blogs written by a free speech barrister and a prominent free speech academic, Jake Rowbottom at Oxford, said different things about what it would mean. One of them suggested the courts couldn't really make any sense of it because it's so clear under the Strasbourg case law that the value you give to speech varies upon what kind of speech. Pornography is not high-value speech, neither is commercial advertising. Political speech, public interest speech is of high value. So was all speech to be suddenly of high value, elevated above everything else, above other convention rights? I mean, really, we were just beginning to think, what possible sense could the judges make of this, particularly when it was applied to sort of detailed legislative schemes like data protection law and like the Defamation Act. So in that way, I don't think it was remotely clear what difference it would make. The exemption of the state almost completely from having this higher, regard for free speech when the state was threatening to do unpleasant things to you because of what you'd said, just struck me as ridiculous. The wokery stuff was just nonsense, and I think it was just a piece of rhetoric. And the privacy law thing, I don't understand how it would work, and more particularly in relation to defamation law. So that particular thing struck me as kind of showing a number of kind of things that Tories were angry about and had very strong feelings about, but it wasn't, I don't think, a coherent piece of lawmaking. It wasn't just that I disagree with it. I think a lot of people looking at it did not know what this would mean and what the judges could or would possibly do with it.
Great, thank you, Gavin. June, do you want to add something?
Yeah, absolutely. I think what Gavin has said, I think we would definitely agree with, and also what I would say as well is that in echoing kind of colleagues from the so-called free speech, not so-called, this free speech sector, so organizations like English Pen, Index on Censorship, Article 19, it's quite frankly quite hypocritical for the government to be, I think Dominic Raab referred to the Bill of Rights bill before it was published as providing a trump card for free speech. It's just extremely hypocritical when you consider it in the round with the other pieces of legislation that really endanger freedom of expression, whether that's the Police Crime Sentencing in Courts Act, just passed earlier this year, which restricts, expands police powers and restricts effectively noisy protest. And also the public order bill that's currently going through that you may have seen passed its third reading yesterday before the Home Secretary today was sacked. But that basically takes measures that were rejected by the House of Lords when they were first attempted to be added to the policing bill as it was in January. It's just very contradictory. And then you have other, legislation that's going through that has, restrictive effects on free expression. And, it just seems very, as with many things in this past legislative session and with this government, very internally contradictory, but fundamentally is designed to crack down on speech and expression, I suppose, that the government just does not like. And I think it's really important to consider the Bill of Rights bill in the round with all the other attacks on rights, so that we see, even when the government promises so-called progressive reforms, it's actually in the round. And obviously when you consider the other aspects of the Bill of Rights bill that would have, decoupled our domestic human rights protections with that of the European Court, actually been in the round, like regressive.
Great, thank you so much for that, June. Tom, I want us to make sure we have enough time to talk about the future of human rights protection, but I'd love to hear a little bit about Article 8 and deportation in the Bill of Rights bill, which kind of enhances the government's role, let's say, with regards to adjudicating deportation cases, in that some certain assessments of the government, judges are required to defer to them. And I was wondering whether you could just talk briefly about this, and then a little bit about the kind of, this is an example of a kind of redistribution of constitutional power with regards to shaping human rights protections in the UK. And if you feel you have time and you want to comment on it, considering this constitutional redistribution that we might have seen with regards to the Bill of Rights bill, what would it look like in 10 years' time if the bill had been passed? So I just gave you loads, but you can pick.
Okay, well, I'll try and be quite brief. The issues that arose in relation to the clauses that related to immigration suffered from essentially the same problems and defects as the clauses that related to freedom of expression, or the clauses that related to other parts of the human rights framework. That is to say, firstly, they were trying to do something that was simply unachievable, which is trying to tell the domestic courts, whether by nudging them in terms of giving weight, or great weight, or a bit more weight, or however much weight the Act specifies should be given to government decisions or to Acts of Parliament, nudge them, or in relation to at least one clause, tell them how to decide cases. Now that is simply unachievable, because, as I said in my first set of remarks, there's an obligation under the European Convention on Human Rights for all states to ensure that there is a way of vindicating those rights before domestic courts. And if domestic courts are shut out or precluded or nudged away from being able to protect those rights, then the UK is not compliant with its obligations under the Convention. Ultimately, you have to make a choice. You decide whether you want to be in the Convention system and in the Council of Europe, in which case you have to allow the courts to adjudicate freely and independently, and you have to allow them to follow, where appropriate, the jurisprudence of the European Court of Human Rights, or you have to leave the system. That's the choice, and maybe we talk about a bit more of that later. But not only was it trying to achieve something that was unachievable, the drafting was just, it was extraordinary. It was going to result in a huge amount of litigation. It led to all sorts, or would have led to all sorts of constitutional confusion. The provisions that we've been remarking on about how much weight you should give to the decisions of the government or piece of legislation. There's just those sorts of provisions are an attempt to sort of influence the way the courts will decide cases, and they blur that division of power that should be there. So those provisions it suffers from all the same infirmities as the other parts of the bill. One further remark on this, on the substance. The main direction of the clauses in the Bill of Rights were aimed at foreign national prisoners, rather than the whole sweep of immigration law. And the issue there is people who have committed quite serious criminal offences, and they are not British, and they're then subject to deportation. Now, in most cases, that is entirely appropriate. It's quite wrong for people to come over here with a permission to come to this country, and then they abuse that by committing serious crimes in this country, and it's, of course, quite right that they should be deported. The problem arises where you've got people who were born here, who've been brought up as British, but have never actually exercised perhaps a right that they have to acquire British citizenship, which incidentally costs quite a lot of money, over £1,000. So they might never have done it, or their parents might never have got around to doing it. Or people who've come over here and lived here and integrated into society and lived here for decades. And there were two cases that were given, two examples that were given of the problem of courts refusing to deport foreign national, so-called foreign national prisoners in the consultation document. And I dug out, I found the tribunal rulings in both those cases and discovered what was said in the consultation document was extremely misleading, because it failed to point out, for instance, that in one of the cases, the individual, and one was in Nigerian and one was a Turkish man. Maybe I've got them the wrong way around, but it doesn't really matter for the purposes of explaining the point. The Nigerian national had been born here, and the tribunal had said he hadn't been to Nigeria since he'd gone on holiday as a toddler. He didn't speak the language, he had no connections there, and yet the government was saying it was a problem that as an adult he couldn't be removed to Nigeria, where he had no connections. He was, for all intents and purposes, British. The other example was a Turkish man who had moved here, lived here for decades, had got married to a British woman, had several children, all British citizens, and a number of grandchildren, all British citizens, had lost all connections, really, with his original country of origin. And again, the government was saying, well, he's committed a crime, he should be sent to Turkey. In these cases, it seems to me, they're not based on the principle that people are coming here on limited leave and are abusing their situation. These are modern forms of transportation. There's no other way of characterising these cases. Moving people to far-off countries where they have no connection, can't speak the language, they're not, in substance, nationals, or they're fully integrated into our society. And it seems to me that the government here is picking cases that don't really have any real political force and manufacturing a problem that doesn't exist.
Yeah, thank you. That's very helpful, and we will get on to the future of human rights protection. But just on this point, I was just wondering whether one of you would like to comment on the kind of changes introduced in the Bill of Rights bill in relation to the government's Rwanda policy. Do any of you have any comments about that? Gavin?
I can say in one word, it would have made precisely no difference whatever to the particular thing they were worried about, which was the Strasbourg interim order, which was effective in international law and had no effect domestically and would have been completely unaffected. I mean, the Bill of Rights bill would have had no effect whatsoever.
Mm-hmm. Thank you.
Also, it was only an interim order. It was only to enable a proper full merits hearing to be heard in the domestic courts. It was a procedural step. It wasn't a hearing on the merits.
In the long term, it might make a difference to the number you can deport to Rwanda, because it's at least possible that you might be able to, with these provisions in, to make it easier to do it. But in a sense, we don't really know, because the truth is the Rwanda deportations of asylum seekers essentially have not been tested in our courts. And I have very serious doubts that they will survive being tested in our courts in the form that the government actually wants. But it's absolutely right. It was the interim order which probably irritated more than anything else. But there's no difference in the interim order, because if we decide to defy an interim order, we are defying something that we have accepted as part of our international legal obligations. And we'll come on to discussing our position in the ECHR at a later stage.
Great, thank you. June?
I just think quickly, I just want to use this as a really clear example of how the process for the Bill of Rights bill was, it encapsulates the problematic way that it was even formulated. Of course, we spoke a bit about the political background and how the Human Rights Act has always been kind of effectively under threat. Just to for context, in 2019, in the Conservative Party manifesto, there was a commitment to update the Human Rights Act, and then Justice Secretary Sir Robert Buckland came into power and came into his role, and then commissioned an independent panel to review the Human Rights Act, not the substance of it, but the kind of structure of it, to see how it was functioning. And so many people responded with such detail and substantive depth, and they went on road shows during the pandemic, to speak to people online and to consult, and they produced a really serious report of 500 pages, effectively saying that the function of the Human Rights Act was, was good. Procedural amendments might be helpful, not all of which we at Liberty agreed with, but, effectively, it was fine. Human Rights Act was really important, actually, in protecting people's rights. Nowhere in the report did they talk about interim measures. They didn't look at substantive rights. And then on the 14th of December last year, the government publishes the Bill of Rights bill and the report of the panel on the same day, and effectively just introduces new measures to the bill, and then into its consultation. And then when the bill is published, that's shortly after the first, I think, interim measure from the European Court. And there's a specific measure on, there's a specific provision saying that courts have to ignore interim measures. And I think that shows how changeable this really serious project, if the government were to actually pursue it, of constitutional, political change, not to mention the effects on so many people, individuals, communities, families. We haven't even spoken about the devolved nations, the Good Friday agreements, peace in Northern Ireland, all of these things. For them, it was just a kind of pick and choose game of things that, were politically interesting to them, or that gained the most headlines, that they decided to just sprinkle into this legislation that then they intended to pass. So I think it just kind of really illustrates the frankly bizarre situation that we were finding ourselves in for the past year.
Great, thank you. So on the topic of the changeable nature of current politics, so we are in a situation where the Bill of Rights bill has been deferred. I don't think it's been formally withdrawn. And we have a Prime Minister who said that in the Tory leadership contest, she said that she would be willing to withdraw the UK's membership from the ECHR. In certain contexts, she didn't say that she was planning to do it, but she said that she would be prepared to do it. I just wanted to think a little bit more about that process. So I had an example about the Home Secretary fulfilling her dream of sending some people to Rwanda before Christmas, but she's now just been fired. So let's say the new Home Secretary, who I think is Grant Shapps, I don't know, but maybe. Let's say the new Home Secretary also has a similar dream and finds themselves another interim order is issued by the European Court of Human Rights, which doesn't, as Gavin pointed out, won't actually have domestic effect, but it might be used as a kind of catalyst for a kind of initially political campaign for the UK to withdraw from the ECHR. So what would the kind of legal and political processes that the government should enter into in order to realise that? Yeah, Dominic, it'd be great to hear from you.
In a funny way, there are not very many legal processes at all. If you want to withdraw from the European Convention on Human Rights, you give notice that you are withdrawing from the European Convention on Human Rights, at which point, I suppose if you want to take it to its logical conclusion, you better then repeal the Human Rights Act. If you do both those things, then you're out of what I would call the convention system. And yes, successive Conservative politicians principally have chunted about this. David Cameron made sort of noises about it in his 2015 manifesto. Theresa May stayed quiet. Johnson chunted a little bit, and Truss has done so. And of course, Suella Braverman, now no longer the Home Secretary, as I understand it. Things happen very quickly at the moment. Was on record for saying she really thought that we should be withdrawing from the European Convention on Human Rights. But the problem is that you can do it very easily, but the consequences are pretty cataclysmic. Firstly, our withdrawal, if you're doing it for the entire United Kingdom, it is undoubtedly in breach of the Belfast Good Friday Agreement, because we have a binding international undertaking that Northern Ireland will be subject to the convention and will be part of the convention. Actually, we had a binding legal obligation to incorporate in Northern Ireland. It was, well, a binding international legal obligation to do that. Secondly, the United Kingdom has always put itself forward, and something I'm rather proud of, as being at the forefront of the international rules-based system. Not a week goes by without a foreign secretary standing up in the House of Commons lecturing, perfectly properly, foreign governments about their breaches of human rights. It completely drives a coach and horses through our authority in this area. And actually, it also affects our trade and cooperation agreement with the EU, because some parts of it, data communication, is underpinned by shared participation in the convention. So any government that wants to pull out will have a succession of civil servants coming along and saying, you do understand, Minister, just how reputationally damaging and economically damaging this could be for the United Kingdom. And because of that reason, I happen to think it's a complete fantasy. And this is why, you know, we're going round and round in circles. Because if you're staying in the ECHR, having a Human Rights Act makes sense. And as the government discovered with the Bill of Rights, because it actually produces potential incompatibilities with the ECHR, firstly, they were going to have huge difficulty getting it through the Lords, and secondly, they were going to discover very quickly that it was going to be pulled to pieces for its incoherence, and some wiser people in government said it was going to make life more difficult and not easier. And so, for that reason, I remain quietly optimistic that for all this background noise, I don't believe a UK government will do this. It would have to be full of a real revolutionary zeal to carry this out. And I just don't, fortunately, I don't see it happening.
Thank you very much, Dominic. I have just a couple of issues in my head. So obviously the Human Rights Act has given constitutional status under case law, so Thoburn. And we've also got the issue of Miller. I don't know, I'm sure that would have implications. So is that something that you can speak about, Gavin?
Yes, I was just going to make two very quick points. So, I mean, on the politics, I had a sort of session with some Tory MPs, very right-wing Tory MPs, and actually they seem to accept that it would need an express manifesto commitment. So I don't see it happening this side of the election, and at the moment it's quite hard, touch wood, to see the Conservatives winning the next general election, perhaps, if that's not too, optimistic. The other thing is, yes, I mean, the Miller point is just that. So I wrote a long, complicated article. The basic upshot with Alison Young, the basic upshot is we think that, because in theory the government could just withdraw from the ECHR using the royal prerogative without any attention to Parliament, but we think that there's an argument that would frustrate provisions of the Human Rights Act, Miller style, and therefore that means that, in fact, Parliament does have a veto in the sense that Parliament probably must also repeal the Human Rights Act, which obviously is up to Parliament. So it can't just be done, in other words, probably by the executive acting on its own. So at least Parliament has to be in there. But yes, I mean, I'm glad to hear Dominic say that, but my perception was this is not something that could happen this side of a general election.
Tom?
Well, this is the political balance, or the political choice. On the one side, you've got supposedly problematic decisions of the European Court of Human Rights. I happen to think the European Court of Human Rights has made a number of problematic decisions, just like most courts, and they can be criticised, and sometimes they can be persuaded to take a different approach. But there really are no major problems, and there's been no major problems either at the European level or looking at the domestic implementation. And it's one of the things I wanted to remark on earlier. If we don't have a Roe against Wade case, a sort of standout case that everyone can say that's where the court has stepped way too far out of its box, or you can look at other cases, obviously, of the US Supreme Court, which went the other way, Dred Scott or something. We don't have any cases like that. I mean, you're scratching around. You've got the Belmarsh case, which Dominic mentioned. The Belmarsh case, the court said that indefinite detention wasn't compatible with the European Convention on Human Rights, but a committee of Privy Councillors set up to decide that issue also said the same thing, and so the Act came to an end. And in fact, the Supreme Court handed the government the template for control orders, now TPIMs, in the same judgment. It was hardly a massive problem for the government. The court itself navigated the government through the issue. You've got prisoner voting. Again, we've heard. I mean, it became really a non-issue. You're scratching around, really, for major problems. So you've got that on one side of the balance. On the other side of the balance, you've got two countries that have withdrawn from the European Convention on Human Rights. You've got Greece, the military junta, way back in the 70s, and you've got Russia. That's the sort of company we would be in if we withdrew from the European Convention on Human Rights. And you've heard what Dominic says about how that would affect our international reputation, our economy, credibility, so far as we've still got any, as a nation. So that's the balance. That's the question. That's both sides of the scale. You weigh it up. Seems to me it's an absolute no-brainer. And yes, there are problems with the convention system. Yes, there are problems with the Human Rights Act. Yes, there are things you can criticise. But what it boils down to is that choice. And it seems to me, when you look at it in that way, I would hope that no British government will be withdrawing from the European Convention on Human Rights anytime soon.
Great, thank you, Tom. So just on that kind of topic of, us potentially leaving or not leaving, and I hope no government would necessarily bring us out of the European Convention on Human Rights. As Gavin said, we may have a different government at some point. And were we to have a different government, what areas of kind of human rights law do you think are most in need of reform? I mean, bearing in mind, obviously, there's only so much you can change it in order to still be part of the European Convention on Human Rights if you're trying to restrict, human rights protections. But if you're trying to enhance human rights protections, then in some sense, the sky's the limit when it comes to the European Convention on Human Rights. So what do you think about this issue of, putting party politics to one side? Where do you think we should be reforming human rights law? Gavin?
Just very quickly, I'd say policing and public order law, where we have a kind of an amalgam of incredibly vague common law powers, although the courts have decided are common law powers like breach of the peace and the common law right to investigate crime, which allowed the police to maintain with no statutory foundation something rather sinisterly called the domestic extremism database, that turned out to be one of those weird police kind of liberties to do things because there's no law saying they can't, kind of Malone style. And then, of course, as we know, a layer upon layer upon layer upon layer of draconian public order legislation, of which there's still more to come. And you could say the same thing about counterterrorism law. We have offences of astonishing draconianness and breadth that I think sit very ill in any kind of democratic society and are only really held in check, ironically, by the ECHR and the courts.
Thank you. June? Oh, sorry, Tom, you can go.
I guess this is obviously a very blue sky thinking question. I guess the first thing though is we have to as I spoke about in the very beginning, I think it's really important to be careful about how we articulate these improvements to human rights law, because we were very careful, and civil society in general was very careful during the process of the Bill of Rights kind of related consultations, not to, in the context of the Human Rights Act, try and make the case for those who would want to eventually repeal it that it needs changing. Rather than that, I think, kind of as you framed it, treating the Human Rights Act and the ECHR as the floor, not the ceiling. And then on that basis, I think there are really, Labour has committed to incorporating the Convention on the Rights of the Child, were it to come into power. Of course, Scotland has incorporated the CRC and is considering, both Scotland and Wales are looking at socioeconomic rights, trying to really enact kind of progressive reforms, but also, maintaining and really upholding the Human Rights Act and the ECHR and all the good things that enables. And of course, Scotland is also looking at, I think it was CEDAW, CERT, and the CRPD and environmental rights and better rights for LGBT people. So it's not there are ideas out there for real reforms and substantive reforms that can actually happen. And similarly, we're thinking about repealing some of the worst pieces of legislation of the last session, whether that's the PCSC Act or Nationality and Borders Act, or whatever legislation manages to pass in this interim period before the next general election, like the Public Order Bill. So there's lots of ideas if opposition parties want to rise to the challenge and really safeguard and protect human rights.
Great, thank you, Tom, and then we'll hear from Dominic and then have a Q&A.
I think probably I would say access to justice. In many ways, it's the right of rights. And it's very much in our own constitutional traditions. Our constitutional tradition is, it's all very well having these wonderful bills of rights like they have in France or in America, but it doesn't mean anything if they're just pieces of paper and they can't be enforced. And it seems to me that there is a real problem in this country, both in relation to civil justice and obviously, as we all know well, criminal justice. People can't get to vindicate their rights in courts. And whether you're talking about, as someone was talking on a panel last week, and I was hearing from one of the leading firms that does legal aid, and they were talking about legal aid deserts. And there's an interactive map apparently on the web which shows you exactly where you essentially can't get access to legal aid because there were no legal aid providers. There were no providers. Even if you, and qualifying for legal aid, I mean, if you've got any kind of assets at all or job, you're not going to get legal aid at all. If you don't have legal aid, you're going to risk your, what scarce resources you have in vindicating your rights. There are costs, risks. You have to pay the risks of the other parties if you do bring claims. And then you've got criminal justice. And whether you're talking about the rights of the victims of crimes, to have the perpetrators prosecuted and tried and put behind bars or fined, or you're talking about the rights of accused people to have their rights determined in a speedy, fair, resourced way. Seems to me that's obvious. I mean, that's the whole system is currently on its knees. So if you were to say to me, if I could sort out one area of human rights law, I think it would be access to justice.
Great, thank you. Dominic?
I agree with that. I think that our justice system is teetering on the brink of collapse, and there are a whole series of reasons for it, but it has been significantly underfunded and neglected for a very long time. It actually predates the coalition government of 2010. It started under Labour, but it's accelerated. And what's happened is, what happens with all government spending is, if you start falling behind, you become less and less effective, and therefore your bid to get more money inevitably gets turned down. And with the justice system, which is demand-driven, this has happened systematically over a long period. And because there are there are very few people who are directly affected unless you get involved with the justice system, it's very easy for government to ignore this. Whoever gets elected at the next general election, I think they're going to be facing a really serious challenge over this issue, because I've watched it happen, because I was Attorney General for a period when it was beginning to happen, and it accelerated very markedly afterwards. I feel very sorry for the Justice Secretaries, although in one case, one of the Justice Secretaries simply accepted it without even arguing against it, which I thought was pretty extraordinary. That said, of course, it could turn into a ECHR issue, because there are some protections about, firstly, being able to enforce your rights, and secondly, about the right to a fair trial under certain circumstances. But it's a pretty long stop issue. I'm rather conservative with a small c. I don't disagree that there are all sorts of rights areas which governments may choose to look at, including socio-economic rights, but I do think that they are, by their very nature, very distinct from the fundamental rights that the Convention was seeking to protect. And I happen to think that we have a really effective mechanism for doing it in the Human Rights Act, one which I said at the beginning of this discussion is deferential to Parliament, doesn't seek to impose judgeocracy, and strikes exactly the right balance, and has proved, in fact, highly effective in raising standards. And frankly, I would just leave it well alone. And I think the longer it's there, the more people will realize how beneficial it is. And if we could just get over this sort of continuous hiccuping about rights being claimed by undeserving people, we would suddenly realize that it's pretty effective. Now, in the past, back before we got into government in 2010, I did do a review and suggested to David Cameron a possible Bill of Rights, but it was preserving the ECHR in its current form. I wondered if we could add some constitutional rights to it to make it more palatable to the public. So things which exist elsewhere, like the period of the Parliament Acts, a whole series of things that you might have added in to make a sort of constitutional document that had greater resonance with the public and therefore might be more attractive to them. And Dominic Raab actually sort of deferred very slightly to that in crafting his own Bill of Rights, but he didn't take it very far. So my view since then has probably evolved. I would just leave it as it is. It works really well.